Hello and welcome to this Field Seymour Parks webinar. My name's Ian McRae and I head up the employment law team here. Essentially today we're giving you an employment law update to make sure you're aware of everything you need to be aware of for 2018. So this is part 2 of a 4-part session, and in this element we're going to be looking at the issues of worker status and how workers should be distinguished from people who are genuinely self-employed. So first thing I'm going to look at is two conflicting decisions, one concerning Uber and the other one concerning Deliveroo. And there's a wide range of worker cases I could have picked upon, but these two give contrasting decisions. Both received widespread publicity. You can see the couple of news reports there on the Uber decision, where essentially they lost their case. And Deliveroo, where they were more successful in establishing that their delivery riders were not workers. So we're going to start off with looking at employee and worker status. What are the different classes and why does it matter? So essentially you have, in basic terms, 3 different classes. You have employees who qualify for the full protection of employment legislation, so the right not to be unfairly dismissed, the right to a statutory redundancy payment. You then have your sort of middle class, which is the idea of a worker, and generally they have more limited protections. So they have the right to national minimum wage, the right to paid holiday, the right not to be discriminated against. And then right at the other end of the scale, you have your genuinely self-employed. So people who are essentially in business on their own account, and they generally don't have any employment protection apart from whatever's in their contract. Now, the recent cases and the cases we're going to be looking at now concern the distinction between somebody who is self-employed and somebody who is a worker. Now, what is a worker? Well, if you are an employee, you will automatically be a worker. That's easy. It's the second category that is slightly more difficult. And essentially, you will also be a worker if you are an individual who performs services personally and you're not in business on your own account. So essentially the relationship is not one of business to client, business to customer. You're not operating as a business yourself. And it's this area, quite understandably, that has caused more difficulties. So we're going to start by looking at the key facts around the Uber decision. So most of you will be familiar with Uber and indeed their position that they are not a taxi company, they are a technology company. And all they do is facilitate the relationship and indeed the contract between the drivers and the passengers. And as such, they treat their drivers as self-employed. The issue has arisen because some of those drivers have sought to claim that they are in fact workers and are therefore entitled to national minimum wage and to paid holiday. Now, the Employment Tribunal originally decided that the drivers are workers when they've got their app switched on, which they get their work through. They're within the territory, they are where they're meant to be, and they're willing and able to accept work. They are workers and should be getting national minimum wage and should be getting paid holiday. And the reason for that decision was essentially that the degree of control that Uber exercised over those drivers was inconsistent with a self-employed status. Now, this case went up to the Employment Appeal Tribunal, and that's what I particularly want to look at today. So let's look at that Employment Appeal Tribunal outcome. Now, they upheld the tribunal decision. They said that these Uber drivers are workers. And part of the reason for that was they said that these drivers can't grow their business or indeed establish business relationships with their passengers. They have to operate on Uber's terms. There's no negotiation. They have to charge what they're told to charge. And they were very much incorporated and integrated into Uber's business and operating under Uber's control. And they weren't convinced that that control was purely required for regulatory requirements. So Uber decision went against them. They are looking to appeal that and we'll talk about that later. But what I want to do is contrast that with the decision in the Deliveroo case. So let's look at the Deliveroo decision and see how we can contrast that with the Uber decision. So for those of you not familiar with the service, it's an apps-based service, essentially allowing the delivery of food from your favourite restaurants to your home or work or wherever you might like it. And again, similar to Uber, they use self-employed contractors to deliver their food. Now, this concerns a decision by the Central Arbitration Committee. And the CAC essentially determines cases about union recognition. And the key point as far as we're concerned here is for those cases for recognition to be successful, the union has to establish that a certain percentage of the individuals are workers and are trade union members. So whether or not these delivery drivers are workers or not was crucial to the union's application. Now, what does Deliveroo do with their drivers? Well, they have a substantial onboarding process. There's training around hygiene, there's trial runs, they do CAB checks. They also offer work via mobile app, so very similar to Uber, although their riders can accept or decline work without any penalty. Equally, Deliveroo are under no obligation to give them work, and there's some short termination notice provisions as well. Now, the key aspect here is substitution. Now, for Deliveroo riders, they have an absolute right to appoint a substitute. And by that, I basically mean someone to do it on their behalf. And they don't need to inform Deliveroo that they're doing it. They don't need to get their approval. And it can basically be anybody, provided it hasn't been someone who's been dismissed for a material breach previously. So someone who's done something similar to gross misconduct. No need for that substitute to have any training. It's purely on the rider, on the delivery person, to ensure that substitute has the required skills. And all they have to do is give them their phone or their login details, and then they can go off and deliver it on the rider's behalf. This is also reflected in the contract, and somewhat unusually or surprisingly, this substitution actually seems to be used, despite the fact that these riders can sort of accept or decline work whether or not they want to. Evidence was put forward that actually these riders do use substitutes, and some of them sort of charged a percentage of the fee to these substitutes. So what the CAC said was these individuals are not workers because there's no personal service here. Because of this absolute right to appoint a substitute, they can't be workers. This is different from the Uber case. Now, there's some pretty serious implications here for most businesses, because despite Deliveroo having quite a substantial process for getting their riders in place to begin with, the training, about hygiene, about certain standards that are required, they then have this absolute right for them to appoint any substitute. And that substitute may not have had any training, they may not know who they are. There's a real lack of control there. And that's something that Deliveroo have obviously decided is acceptable for their business model, or that there's sufficient protection in place. But for many businesses, that simply won't be acceptable. So let's have a quick look at what's next. Uber are appealing their decision, and that's going to be heard before the Court of Appeal at some point in 2018. The Deliveroo decision can only be challenged by judicial review. There is still some time for them to do that, depending upon when you're watching this, but that appears to be unlikely that that's going to be challenged further. What's probably most important is the decision of the Pimlico Plumbers case, where we're likely to get some further guidance on this substitution worker point in February of this year. Also, we've recently had the Taylor Review and the Work and Pension Committee report, which has made various proposals about how the government can ensure these workers are getting sufficient protection. And essentially they've suggested that worker status should be a rebuttable presumption, so people are workers unless you can establish otherwise. Possibility of some sort of pay premium if there's no guaranteed hours, an entitlement to a written statement of terms, much like an employee, and this idea of naming and shaming employers who don't get it right. Now those are all just proposals, and the government's yet to respond to them formally, so I don't think we need to be too concerned about them yet, but this is clearly an area which might develop further. So in terms of action points, you need to review and audit your relationships. Are you correctly classifying your employees, your workers and your self-employed? You should also consider setting review dates for those relationships. So what may be a self-employed relationship now may not be in 6 or 12 months' time. The contract needs to reflect the reality of the relationship. So calling someone self-employed when they're not is not going to help you. And if you do think you've got it wrong, you should take advice on how to move that individual to a new contract. Because essentially you're not going to want to do so in such a way that suggests that you've wrongly labelled the relationship to date, because again that may give rise to back payment claims for national minimum wage or holiday. Review and amend your contract terms as well, and also you should be aware that both the CAC and the Employment Tribunal did suggest that if you wanted to do so, you could organise your business in such a way that the individuals providing services are not workers. So that is possible, but you need to understand the restrictions that may place on your business. So a few final points. Usual caveat, very brief introductory summary to these issues. Always take your own legal advice on your specific circumstances. We will be updating on those developments expected in 2018. If you'd like our free email updates, then just drop me a line. And equally, please do get in touch with any questions, suggestions or feedback. And as I said earlier, this is only one part of a 4-part series, and if you'd like to review the other elements, then you'll find that we cover holiday pay, general data protection regulations, monitoring at work, and some other developments that are expected in 2018.